Here we go. It is Thursday, Memorial Day weekend Thursday, so hopefully everyone has some holiday plans set up. I am probably going to be home with my family, barbecuing and stuff like that, so hopefully you all have some really good plans as well. My name is Matt. This is Why Libertarian, coming at you every Monday through Thursday at 7 p.m. Eastern. Tonight is our Natural Rights Talk night, so every other week on Thursday night, we talk natural rights. And it's going to be fantastic. We're going to go over some more stuff. We're just kind of, it is hella deep, and we're just trudging through it and making sure to get as much down on tape and out in the public purview as possible as we move forward with that. So before we get to that, and my usual guest, remember, like, comment, subscribe, share, hit the notification bell, retweet. I am going to scroll my link tree in the bottom. Go to my link tree and go to the top link, or go to my Twitter and go to the pinned post. I am giving away 100 Hive, 100 crypto on Monday the 31st, meaning this upcoming Monday, Labor Day, or Memorial Day, excuse me. And yeah, I'm going to be live at 7 p.m. and I'm also going to give the instructions for the next giveaway. So definitely check that out. It's free to enter. People make money on their posts. I've seen a ton of people put posts in and they make $5, $10, $15 on the post, just getting onto the platform and putting that first post up and getting crypto for just their activity on the blockchain. So definitely get in on that. You have this weekend to do it. That's it. Last shot. So final reminder. That being said, we have, as usual, every other Thursday, Josiah Hinkle with us from the American Natural Rights Foundation. Josiah, how are you?
I'm good. How are you doing, Matt?
Awesome. Thank you for bearing with me through my very verbose intro here. It gets longer every week, doesn't it?
No, I think it's exciting that you got the raffle going, or I don't know if it's a raffle, but you got the giveaway going on. That's pretty awesome.
Yep. Yeah. Anything we can do to decentralize, communication and stuff like that, I think is huge. So, yeah, I'm really looking forward to it. So, all right, what do we got this week? We got last week we had a ton of stuff we covered. This week looks like we got a lot too. So, what are we looking at?
We've got, all right, so I'm going to tell you about American jurisprudence, objective morality in small government, and valid waivers. I've been telling you about that for a little while, so we're going to cover that this time.
Yeah.
But basically, so starting off with it is just jurisprudence, and this is just, essentially what we've been talking about this whole time. But I thought I'd read this to you to give you kind of like a, just kind of an overview of some competing schools of thought.
Sure.
So jurisprudence, from the Latin term jurisprudentia, which means the study, knowledge, or science of law, in the United States more broadly associated with the philosophy of law. One type of jurisprudence raises fundamental questions about the law itself. These questions seek to reveal the historical, moral, and cultural underpinnings of a particular legal concept. The Common Law, 1881, written by Oliver Wendell Holmes, Jr., is a well-known example of this type of jurisprudence. It traces the evolution of civil and criminal responsibility from undeveloped societies where liability for injuries was based on subjective notions of revenge to modern societies where liability is based on objective notions of reasonableness. Another type, and one of the fastest growing bodies of jurisprudence, focuses on even more abstract questions, including what is law? How does a trial or appellate court judge decide a case? Is a judge similar to a mathematician or a scientist applying autonomous and determinate rules and principles? Or is a judge more like a legislator who simply decides a case in favor of the most politically preferable outcome? Must a judge base a decision only on the written rules and regulations that have been enacted by the government, or may a judge also be influenced by unwritten principles derived from theology, moral philosophy, and historical practice? Four schools of jurisprudence have attempted to answer these questions.
Mm-hmm.
Formalism proposes that law is a science. Realism holds that law is just another name for politics. Positivism suggests that law must be confined to the written rules and regulations enacted or recognized by the government. And naturalism maintains that the law must reflect eternal principles of justice and morality that exist independent of government recognition. Modern U.S. legal thought began in 1870. In that year, Holmes, the father of the U.S. legal realist movement, wrote the first major essay for the American Law Review, and Christopher Columbus Langdell, the father of U.S. legal formalism, joined the faculty at Harvard Law School. So when reading about modern legal thought here in just a moment, you'll understand why we've come so far away from the science, that our founding fathers discovered, and those political societies which they had envisaged, they created based on the philosophy of those.
Sure.
So formalism, legal formalism, also known as conceptualism, treats law like a math or science. Formalists believe that in the same way, a mathematician or scientist identifies the relevant axioms, applies them to given data, and systematically reaches a demonstrable theorem. A judge identifies the legal principles, applies them to the facts of the case, and logically deduces a rule that will govern the outcome of a dispute. Judges derive relevant legal principles from various sources of legal authority, including state and federal constitutions, statutes, regulations, and case law. Formalists also rely on inductive reasoning to settle legal disputes, whereas deductive reasoning involves the application of general principles that will yield a specific rule when applied to the facts of a case. Inductive reasoning starts with a number of specific rules and infers from them a broader legal principle that may be applied to comparable legal disputes in the future. Griswold v. Connecticut provides an example. In Griswold, the Supreme Court ruled that no express provision of the federal Constitution guarantees the right to privacy. And although no precedent had established such a right, an individual's right to privacy can be inferred from the First, Third, Fourth, Fifth, Ninth, and 14th Amendments, and the cases interpreting them. English jurist Sir Edward Coke was among the first to popularize the formalist approach to law in Anglo-American history. Coke believed that the common law was the peculiar science of judges. The common law, Coke said, represented the artificial perfection of reason, obtained through long study, observation, and experience. Coke also believed that only lawyers, judges, and others trained in the law could fully comprehend and apply this highest method of reasoning. The rest of society, including the King or Queen of England, was not sufficiently learned to do so. Langdell invigorated Coke's jurisprudence of artificial reasoning in the United States during the second half of the 19th century. Langdell compared the study of law to the study of science and suggested that law school classrooms were the laboratories of jurisprudence. Judicial reasoning, Langdell believed, parallels the reasoning used in geometric proofs. He urged professors of law to classify and arrange legal principles, much as taxonomists organizes plant and animal life. Langdell articulated what has remained the orthodox school of thought in U.S. jurisprudence throughout the 20th century.
So just to ask you a quick question there. So it seems like this is essentially a very dispassionate form of jurisprudence, right? Like the
Yeah.
idea that you're approaching it essentially like a scientist.
Yes, absolutely, completely objectively, and that's even why he remarks about it being kind of closed off to people who aren't trained in that particular study. Is just because it gets very complex and subtle. There's a lot of subtleties and nuances and stuff that not being a person who studies it wouldn't really know. But for the most part, we're talking about things that are unique circumstances that come up with, like, you have one individual who is some kind of relationship with another individual, and based on that relationship, and maybe they have a contract together, that's the relationship, or maybe one works for the other one as an employee, as a U.S. citizen, or whatever the case may be, and then there's some peculiar thing that makes that case interesting and different than just a normal, conventional, reasonable case, and that particular issue would have a normal person would have difficulty figuring out how you would, come about concluding, but a person who had more of a formal education would have a lot more resources and capacity to, solve the question.
Yeah, and my understanding in comparing it to like a geometric proof, that
Right.
geometric proof is essentially this kind of like stepwise or systematic approach to going from, the question to the answer, or basically proving what the answer should be or the solution should be, which means that you can't just say, if this is what happened, this is how you rectify it. There's actually a sequence of kind of like rational or how should I put it, calculations or something that need to be gone through before you get to that point.
Just generally speaking, we would call it the reasoning, and you'd find it in the opinion generally, but yeah.
Okay, awesome.
Yeah, so get a load of this, man. If this doesn't cause you to break all the glass in your house, then hopefully it brings a smile to your face.
Yeah.
Realism. The realist movement, which began in the late 18th century, and gained force during the administration of President Franklin D. Roosevelt, was the first to attack formalism. Realists held a skeptical attitude toward Langdellian legal science. The life of the law has not been logic, it has been experience, Holmes wrote in 1881. Notice the timing.
Like 2 years right before Webster.
2 years, actually just about 15 years after. But
oh, I'm sorry. Yes, yeah. I'm getting my decades mixed up. Yes, yeah.
Okay.
So, but in
again, makes a lot
very
of sense.
short order. Yes.
Yeah. So realists held two things to be true. First, they believed that law is not a scientific enterprise in which deductive reasoning can be applied to reach a determinate outcome in every case. Instead, most litigation presents hard questions that judges must resolve by balancing the interests of the parties and ultimately drawing an arbitrary line on one side of the dispute. This line is typically drawn in accordance with the political, economic, and psychological proclivities of the judge. The judge does not base the determination on a precise algebraic equation. Instead, the judge balances the competing economic and social interests of the parties and rules in favor of the litigant with the most persuasive case. Realists would thus contend that judges who are ideologically inclined to foster business growth will authorize the continuation of a harmful activity, whereas judges who are ideologically inclined to protect the environment will not. Some realists only sought to demonstrate that law is neither autonomous, apolitical, nor determinate. For example, Jerome Frank, who coined the term legal realism and later became a judge in the U.S. Court of Appeals for the Second Circuit, emphasized the psychological foundation of judicial decision-making, arguing that a judge's decision may be influenced by mundane things like what he or she ate for breakfast. Frank believed that it is deceptive for the legal profession to perpetuate the myth that the law is clearly knowable or precisely predictable when it is so plastic and mutable. Carl Llewellyn, another founder of the U.S. legal realism movement, similarly believed that the law is little more than putty in the hands of a judge who is able to shape the outcome of a case based on personal biases. Except that the whole idea of having a judge is that they are an unbiased third party.
Yeah.
Other realists, such as Roscoe Pound, were more interested in using the insights of their movement to reform the law. Pound was one of the original advocates of sociological jurisprudence in the United States. According to Pound, the aim of every law, whether constitutional, statutory, or case, should be to enhance the welfare of society. Jeremy Bentham, a legal philosopher in England, planted the seeds of sociological jurisprudence in the 18th century when he argued that the law must seek to achieve the greatest good for the greatest number of people in society. Bentham's theory, known as utilitarianism, continues to influence legal thinkers in the United States. Law and economics is one school of thought that traces its lineage to Benthamite jurisprudence. This school, also known as economic analysis of the law, argues that judges must decide cases in order to maximize the wealth of society. Another school of thought Bentham influenced is known as legal pragmatism. Unlike law and economics exponents, legal pragmatists provide no formula for determining the best means to improve the welfare of society. Instead, pragmatists contend that judges must merely set a goal that they hope to achieve in resolving a particular legal dispute, such as the preservation of societal stability, the protection of individual rights, or the delineation of governmental powers and responsibilities. Judges must then draft the best court order to accomplish this goal. Pragmatists maintain that judges must choose the appropriate societal goal by weighing the value of competing interests presented by a lawsuit, and then using a grab bag of anecdote, introspection, imagination, common sense, empathy, metaphor, analogy, precedent, custom, memory, experience, intuition, and induction to reach the appropriate balance. So basically anything you want. Pragmatism, sometimes called instrumentalism, is best exemplified by Justice Holmes' statement that courts decide cases first and determine the principle afterwards. This school of thought is associated with result-oriented jurisprudence, which focuses more on the consequences of judicial decision-making than on how relevant legal principles should be applied.
This is collectivism applied to the judicial system.
Exactly.
Like this is like, okay, what do I want the outcome to be, and then I'll back into my logic for it in order to get there. Like this is abhorrent.
It's totally usurpation.
Yeah.
Yep. Power hungry judges. Yeah. Basically fundamentally changing it with these radical and progressive, legal movements. And a lot of it before our time, so that's significant. Like, there's nothing we really could have done about most of the stuff that we've been talking about, just because it's been way before us,
Well, so, and you called attention to the timing here. It came during FDR, right? And that was very much so, the aftermath of, or at least
it's before that, but definitely, expanded.
Yeah, and so it's in the aftermath essentially of the Civil War, right?
Mm-hmm. Exactly.
And we're now talking about the collective instead of the individuals actually involved in the dispute.
Right. We're honestly talking about just like an oligarchy of judges. I mean, what do you call
who can indiscriminately just
by their whim?
Decide,
arbitrary government.
Yeah. And what's best for society is this. So even though you weren't wronged, I am going to judge accordingly based off of society, not what happened to you. Yeah.
Complete insanity. So I'd ask you, where is it that these judges presume to get the authority to have that, assume that role or that power that the Constitution didn't give them?
Well, I don't know. I'm not sure if they reference it, but it definitely seems like they are claiming a higher moral authority, at least, than most
it doesn't matter.
folks.
That's only appropriate in an equity jurisdiction. When you're in a court of law, the law has no, there's I forget what the word is, but they're like, the law is what it is, and that automatically creates an end. And so that's basically the difference in England. That's the difference between having a judge, or I think it's called a chancellor, who
Yep.
exists in a court of equity, and then you've got a justice, either a justice of the peace or a judge in the court of law. So a judge has no discretionary authority, whereas a chancellor was empowered to make law on the spot, right? Just like this.
Yeah.
But that's the thing. That, again, when we talk about courts, we'll talk about that. But how, equity and the common law jurisdictions kind of got muddled here in the United States by practitioners. But yeah.
And neither of us lived during this time period, but I wonder what kind of pushback happened as a result of this.
Oh, it's really interesting to hear. Even as late as 1979, there's a publication of a latest edition of the Handbook of Common Law Pleading.
Mm-hmm.
Like, when you get into that, it's just like, it's all about, no, we definitely did not get rid of the common law. And it's even asinine to have such a conclusion, because and this is the thing, is like it was saying in there, I can't remember where exactly, but it was talking about whichever has like the most persuasive case. I think maybe it wasn't that. Anyways,
they were talking about the most compelling case or something like that. It was, hold on. Why can't I find it here? I know what you're talking about, though.
Well, I'm not sure. It's all right. I forgot what I was even going to say about it anyways.
That's okay. We can move on. If it comes to you, we can double back. But yeah, no, but the fact that this persisted, that not only did it come to be, but it persisted that long is appalling. It's absolutely appalling. Like, this is the antithesis to what people would think the legal system is supposed to be.
What I was going to say before is, actually, there's a relationship between the common law and like the science of law, kind of, as we talked about, where what the common law did was, because it had been around for so long, it literally became boiled down to 11 causes of action, which, could move a court. And so that essentially means that every instance, every possible wrong that someone could do to you, that you would seek remedy for, was covered within these 11 categories. Whereas the laws that we have now are not categorical, but rather like, I don't know, specific, particular. I don't even know what word you'd use to describe it, but it just makes it all like ridiculous. Whereas the law used to be a very simple thing. You know what I mean? Yeah. So shoot.
We were starting positive law versus natural.
All right. Yeah. Sorry. So the realist formalist dichotomy represents only half of the jurisprudential picture in the United States. The other half comprises a dialogue between the positivist and natural law schools of thought. This dialogue revolves around the classic debate over the appropriate sources of law. Positivists maintain that the only appropriate sources of law are rules and principles that have been expressly enacted or recognized by a governmental entity, like a state or federal legislature, administrative body, or court of law. These rules and principles may be properly considered law, positivists contend, because individuals may be held liable for disobeying them. That's because they don't understand that there are consequences for disobeying the natural law, but they're longer term. And some of them are more subtle. But positivists believe that other sources for determining right and wrong, such as religion and contemporary morality, are only aspirational and may not be legitimately consulted by judges when rendering a decision. Natural law proponents, or naturalists, agree that governmental rules and regulations are a legitimate source of law, but assert that they are not the only source. Naturalists believe that the law must be informed by eternal principles that existed before the formation of government and are independent of governmental recognition. Depending on the particular strain of natural law, these principles may be derived from theology, moral philosophy, human reason, historical practice, and individual conscience. The dialogue between positivists and naturalists has a long history. For many centuries, historians, theologians, and philosophers distinguished positivism from naturalism by separating written law from unwritten law. For example, the Ten Commandments were inscribed on stone tablets, as were many of the laws of ancient Greeks. Roman Emperor Justinian I reduced much of his country's laws to a voluminous written code. At the same time, Christian, Greek, and Roman thinkers all appealed to a higher law that transcended the written law promulgated by human beings. Prior to the American Revolution, English philosophers continued this debate along the same lines. English political thinkers John Austin and Thomas Hobbes were strict positivists who believed that the only authority courts should recognize are the commands of the sovereign, because only the sovereign is entrusted with the power to back up a command with military and police force. First intimated by Italian philosopher Niccolò Machiavelli, the sovereign command theory of law has been equated in the United States with the idea that might makes right. And so it might be interesting to note that Hobbes actually supported slavery. Essentially the fact that slavery, right, as it says, existed backed up by military or police force, proved that it was legally and morally appropriate to Hobbes. So like his argument was that those not willing to risk life and limb to try to escape were essentially better classified as servants by contract, except that they're contracting for their liberty and for their life.
So he's basically saying that a police state is warranted because if the people didn't want it, they would rebel.
Right. Except you'd contrast this with the fact that he would also say those who decide to try and get away would be basically, to escape their masters would be in breach of the contract and would be liable for punishment. So it's metaphysical jurisprudence, that's...
So you're screwed either way,
It's soft. Yeah, that's all it is. So, contrasted with the writings of Hobbes and Austin were the writings of John Locke in England and Thomas Jefferson in America. In his second treatise on governments in 1690, Locke established the idea that all people are born with the inalienable right to life, liberty, and property. Locke's ruminations about individual rights that humans possess in the state of nature prior to the creation of government foreshadowed Jefferson's Declaration of Independence. In 1776, the Declaration of Independence announced the self-evident truth that all men are created equal and are endowed by their Creator with certain inalienable rights, including the right to life, liberty, and pursuit of happiness. This was a fundamental systemic acknowledgement that there is an objectivity to the law, and that objectivity didn't allow for two different conclusions regarding the same matter. This is what makes it a science. The discovery and observation of an objective morality is the last piece that takes positivist doctrines and forever puts them to rest under the consistency found in the rigors of a scientific study. So objective morality is essentially what puts positivism to rest, and it also honestly makes realism look like an affront to justice.
Which it basically is.
Next, let's take a look at objective morality. So the laws of nature include an objective morality. The founders came to this realization when they saw the morality of the Christian religion and paired it with the objectivity of the experimental sciences. This led to the natural discovery of objective morality, and the evolution of the American political philosophy was a natural result. This is why you find modern political philosophers discover overlap when they critically examine religious texts, each varying in what moral values are revered and the degree to which those values are applied in daily life, but each recognizing a definite and immutable objectivity of morality itself. Inquiries, hypotheses, conclusions, theories, methods of investigation, and even creative invention develop in a multitude of instances independently of each other, because there is a resounding consistency in the laws of the natural universe. This consistency allows independent observers to come to the same conclusions and discoveries. And this is the fundamental basis of the legitimacy of the scientific investigation, scientific data, or conclusions based on them. While investigations and conclusions are exposed to the effects of bias, as all scientific pursuits would be, our duty as good scientists is to extinguish all bias and find the truth of our reality. By comparing the works of each individual as it relates to objective morality and fervently seeking after the truth, all of mankind is progressively evolved to a state more consonant to the laws of the natural universe, as they are the most fundamental of all truth relative to human existence, from which no man can escape. The way evidence, observation, and comprehension limit how informed a scientific study can be, the same is true of the study of all aspects of the natural law. But our observations, our evidence, which informs our ability to discern the laws of morality, are made out of moral values, intellectual perspectives, and wisdom of the highest degree, each bound by force of conscience. It's not practical to expect primate humans, to observe or even know the entirety of the laws of morality, such that no infringements ever occur. Not until all people on the planet are edified by the most progressed moral values, intellectual perspectives, and highest wisdom available in all cultures, times, and peoples of any distinction whatsoever, will this ability to live in complete harmony with the laws of nature be possible. But this shouldn't stop us from immediately observing the objective morals we are able to discern. Because just as with other laws of nature, there is a degree of self-evidence that exists when put to the test of observation, consideration, and reflection. As we grow in mind and maturity, we are the more equipped to discern the moral law, and we discern very much through everyday experience. So I was going to say, for example, when I was younger, I was picked on a lot as a kid. Mm-hmm. And so now, if I was to make a joke, I wouldn't make someone the object of that joke if that was to, in some way, disgrace their dignity. Mm-hmm. And so, that experience had an impact on me. Or, another example is, when I was younger, I retaliated against someone who had mistreated me. But after I did so, I ended up feeling guilty because I ended up reflecting and realizing that, to want justice was actually legitimate. That was warranted. Basically compensation for what happened to me. But to make, have the desire to make the other person suffer, my personal sense of vengeance was not justified. And so, with that experience, I now am, when I'm mistreated, I now just seek justice and avoid any kind of, action based on vengeance. So this is what we mean, when we're talking about just everyday experiences can actually inform you as to what the natural law is.
Yeah. And this also kind of points to the idea that, as a child, you don't necessarily, you might kind of inherently have an inclination as to what the natural law is, but it really requires, or doesn't necessarily require, but the objective morality of the natural law becomes more evident as you have more experience and live more years.
Yeah. Yeah, for sure. It comes, like I was saying, comes with maturity and, definitely. So man is an erring creature, having to seek out perfection rather than being born for its capacity. He's bound to transgress the law. These transgressions, according to Christian morality, are seen as honest errors. None being perfect, no one can live an entire life without at some point violating the law. The solution, as conceived by our founders, was to implement the court system as they understood it in their county courts. This implementation required the use of what was called a notice and demand before any legal proceeding could take place. That is, before any third party could be invested with the right to execute the will as embodied in the law, a notice and demand had to be served on the party to be decided against. This gave the violator an opportunity to correct his behavior and make amends. So this notice brings attention to the law violated, and it also demands the ceasing of and recompense from the violation. Good moral Christians have no desire to harm others, so when a harm has been worked as a natural consequence of an action, whether by accident or misunderstanding, an honorable man wishes to right the wrongs he has transgressed and make up for what he has done. There's no reason for moral men to not work things out entirely amongst themselves. So if you recall back, we discussed honor and dishonor, mm-hmm. which, is kind of like the means of, the process of being able to do that without necessitating a political society, to exist.
Yeah.
Let's see here. So, again, and that's so long as, each honors the other's presentments.
Yeah,
But this
which
is
is interesting because we don't necessarily live in that world right now, right? Like, so
right.
there's not always, in fact, more often than not, it's not like, say you have some kind of gripe with your neighbor. Um, more often than not, nowadays neighbors are essentially jumping to the conclusion of some bringing in some kind of third party in order to kind of officiate that discrepancy,
Mhm.
whereas this normal operation is, you formally essentially send notice and demand and say, look, like, your tree's laying on my property, like I demand that you remove it, right?
Mhm.
Whereas nowadays we just kind of short circuit that process in a lot of things, and it's not just in terms of how we deal with kind of like interpersonal conflict. It also has to do in terms of criminal proceedings. I think this is something that is not abided by, right?
It would, yeah, definitely. I'm not sure that our founders, got that far, but if you take the Christian morality, to its, if you extrapolate it to its logical conclusion, it definitely would include that. I mean, consider Jesus saying, "Forgive them," when he himself was being the victim of murder, right?
Yeah.
So, um, let's see, where were we? So this intervening capacity to work out whatever issue instead of fight over it was a remarkable evolutionary progression of the philosophy of natural law. This very reasonable intervention made so much of what used to be resident in the state completely unnecessary. And this was a true stride toward the anarchical conception of human freedom and liberty. This ability to work it out would be in every instance excepting two, and those are when the parties are differing or have differing beliefs about the facts of the situation, or when there's an error or some incongruity in each party's conception of what is viable law. So for these two instances, the founders utilized the age-old institutions which have upheld human liberty for almost a millennium, a jury of peers through a court of law.
Hmm.
The natural law in four parts. So first, the discovery of law-based dispute resolution, and that's essentially form and substance, like we talked in the beginning.
Mm-hmm.
Number two, discovery of scientific or universal law, and that's right, like objective reality.
Mm-hmm.
And number three, discovery that human behavior is a science. So that's where we get our objective morality. And then four, this discovery of the ability to work it out. Basically, while the Romans developed a sophisticated legal system and legal culture by 27 BC, such was too advanced for the societies of the next almost 1,000 years, as they would instead traverse the Dark Ages. The Anglo-Saxon philosophy in 900 AD of a body of objective law that we now call science, spanning every human, every instance, even the entire universe, was too advanced to take hold in the broader societies of Western culture until the experimental sciences of the 17th and 18th centuries. And this is why you hear, Blackstone and Taylor refer to metaphysical jurisprudence. It's the appropriate label for those things which supposedly exist separately from nature, but
Mm.
people of this political philosophy, the naturalists, would argue that no such thing exists. So
Fair enough.
similar to the discovery of science, the ability to work it out didn't take hold until the Christian morality of the founders, or their more immediate ancestors, as the case may be, dominated the political society. The morality of the Bible, revealed through self-study, progressed the philosophy. The concepts of mercy, forgiveness, and love inspired this new revolution, stabilizing the interactions of men without the need for anything more than a small, limited government to deal with criminals, those who willingly and with malicious intent violate the rights of others. In other words, those who didn't share the Christian morality of, the loving service of the brotherhood of man.
Mm.
So, a political society is made by the mere act of one man agreeing with another as one union to enforce their common rights for mutual benefit. While this is a crude example by function, it's no different than a political society much as we have, where people have banded together to empower each other to protect and secure their mutual liberty. Our founders saw in the system of the county courts just the means to provide that small limited government. So this is where we get courts and the small government idea. The founders established the application of the court system to principles embodied in the natural law to effect a small limited government. And this is actually where we get the phrase, a government of law and not of men. But justice was a classical feature of the law-giving God of the Judeo-Christian religion. With the freedom offered by the objective morality of the natural law paired with this system of justice in the courts, our founders completely embraced this new philosophy and made it the foundation for their political societies. And this is where our system gets the common law. And actually, this is one of the things that you can learn at the American Natural Rights Foundation, is we will actually teach you how to, in your own court of law, to file a cause of action against a public official in their individual or private capacity to seek some remedy for a violation of your rights. But you can feel free to get in touch with us to learn more about that. But just going on here, in a court of law, the tribunal is separate from the magistrate. So the jury is there to decide on the facts and the law of the case, not the government official. And the judge is there in a ministerial capacity to help the court and its parties manage their proceedings to some final resolution. In America, we have juries of 12, although I've heard some bastardizations of this. I'm not exactly sure where they come from, but when the plaintiff files his first cause of action, I'm sure you remember we talked about that, the section in there called the points and authorities, where he appeals to the law of the sovereign. Well, he being the sovereign, he dictates the law of the case. And he voluntarily gives his sovereign prerogative to the judge to judge the case over to the jury. And along with the defendant, he agrees to appoint this third-party arbiter to decide the matter between them. If the defendant dishonors the presentments and ignores the opportunity to make his defense, then the court proceeds without him. For a defendant to be convicted of violating the law, your law must conform to what a jury of 12 individuals unanimously finds reasonable. And your evidence must be convincing enough to establish in each of those 12 jurors that the facts as you present them are the truth of the matter. But for a defendant to beat any liability to your law, his defense must only convince one juror to doubt the facts you assert, or persuade the conscience of one juror that the law you wish to impose is unjust. This naturally leads the laws of our American society to be reasonable, and it compels the actions of the people to be reasonable actions. If a jury was to attempt to impose a law on one that does not conform to the laws of nature, it would be nothing more than mob rule, an arbitrary exertion of force which constitutes an original aggression. Each of those jurors and the plaintiff could then be made the object of a suit for specific relief, which would expose them to legal liability. When the tribunal has handed down their judgment in the matter, and if the defendant does not willingly comply with the judgment, or if he did not present his defense, then the sheriff is there to serve the judgment to the defendant. This is why local judges and sheriffs, all throughout history and still today, were elected positions. So the people had like an immediate control over the enforcement arms of the law. The laws of their local communities. And it also, as you can see, it provided a direct connection between the sovereign and the actual dictation of the law of the community, right? Because each time, you had an offense, you would bring this law before the court, and the jury would decide, if the defendant had decided to have the jury choose. Again, that's a thing that you both voluntarily choose to do between the two of you. It's an agreement that you make to, outsource the judgment to this third party, and to make it binding on the two of you. But essentially, yeah. So where were we?
I believe the bold. This is the small government.
Yeah, this is the small government envisioned by the founders, as it was the only function of government that existed in undeveloped, unincorporated towns and villages of the states. This common law system is what was there before any states were formed in the various territories of the United States throughout our history, and this common law system was also still maintained in the nature of courts of law, even in those cities and towns that were organized into civil corporations. It's even remarked in the Constitution. So even the federal jurisdiction is courts of law. So we'll talk more in depth about common law courts, later. We'll have a little part about that, but recognizing that men are imperfect beings with much to learn about perfect behavior, the current era used voluntariness to establish agreements which bound them by oath to identifiable terms. The laws of nature still needing more comprehensive discovery, the terms of a contract or oath clearly define the duties in the interim. And this includes all political action, which just means social action and contracts. So we're learning all the time how the natural law works in relation to human behavior. For example, in a very simplified sense, we have learned that those suffering from clinical psychopathy actually are people with 1, a genetic predisposition, 2, who've suffered a traumatic event around age 2, usually sexual, and 3, a violent event around some age like 7 to 11, and I can't exactly remember, but despite the simplification, the point is we recognize cause and effect in a realm of human behavior where we would normally hold conventional concepts concerning choice to be paramount. Choices can be logically punished. Causes, however, are better understood and mitigated. In another example, we've learned 2 factors that significantly influence drug addiction are unsupportive community and environments lacking stimulating engagement. So protecting children from trauma and violence and choosing healthy breeding practices, like avoiding bad genetic predispositions, or investing in engaging and supportive community and environments will go so much farther in solving psychopathy and drug addiction than will a million years of throwing people in jail for those behaviors. And this is the connection to the natural law, the fact that these things that are happening are actually a consequence of nature, right? We're actually a being of nature. Again, a naturalist will say there is no such thing that sits apart from nature. That's all metaphysical, right?
Right.
So discovering the influence that give rise to human behaviors, including choice, is actually putting us on the path of realizing what true justice according to the natural law looks like. So go ahead.
In that second example, the idea being that, say, take, substance abuse, criminal law as it currently exists. So essentially what it's saying is that those laws are essentially violating natural law because it's not really affecting the actual cause of the problem, right? Like it is.
Well, they'd be violating natural law just because their liberty was being taken. They have a right to smoke the thing or do the thing or whatever it is. Now no one in their community or family will deny they might have a problem, and that's a real thing. And that's where we're talking. That's what comes into what we're talking about. If they had a more supportive community, right, and if they had a more engaging environment, these would not actually, these predispositions and genetic inclinations would not be
as realized as they are in the population.
Exactly.
Right?
Yeah. Exactly.
Yeah, and that goes right to the heart of, like, are we actually trying to solve the problem?
Exactly.
Or are we just trying to punish behavior?
Right? If we had money going more toward rehabilitation than punishment, you know what I mean? And I don't mean like penal rehabilitation. I mean actual, like what we're talking about, right? Taking care of those causes that gave rise to these behaviors, they'd be far more effective than what we're doing now, which doesn't necessarily take into account the cause and effect nature of choice.
Right.
So next, I just wanted to clarify a couple terms because I thought it might help your audience when they're thinking about objective morality in practice.
Sure.
Essentially, you've got ownership and property in the natural law. So owner is defined as the person in whom is vested the ownership, dominion, or title of property. Proprietor denotes an absolute and unqualified title. So unqualified is defined to be not modified by conditions or reservations, absolute. Dominion is defined to be ownership or right to property or perfect or complete property. Or as it would have been in Old English dominium, in the civil and Old English law, ownership, property in the largest sense, including both the right of property and the right of possession or use. Absolute is defined as free from every restriction, unconditional, perfect, complete, entire, possessed as a quality in the highest degree, or possessing the essential characteristics of the ownership. Property is defined to be an interest a man has in anything. Interest is the most general term that can be employed to denote a right, claim, title, or legal share in something. More particularly, it means a right to have the advantage accruing from anything, any right in the nature of property, but less than title. Absolute interest is implicated when a person's property is so completely vested in that individual that no contingency can deprive him of it without his consent. So too, he is the owner of such absolute interest who must necessarily sustain the loss if the property is destroyed. And the title may be defined generally to be the evidence of a right which a person has to possession of property. So your title, right, the evidence to your natural rights is that you're a man or a woman, a natural human being. The term property can implicate anything and everything. Those things which you have a material interest in, no one can claim an absolute or perfect ownership of, which means things like the Exxon oil spill, right? Like in Yellowstone that happened, I think it was like in 2011 or something. Or like the barium and strontium oxides that are polluting the air and the ground from the chemtrails, right? This would actually expose employees of Exxon and employees of, the military or the government to civil liability, right? And since the same loss is incurred by all the people who have an interest in the property, right, in the same property, a lawsuit could be filed for each one, each person could file a lawsuit. So essentially, you could imagine, in their own court, they could file this lawsuit, and you could imagine how, if the entire population got behind it, claiming a property interest in the Yellowstone River, like that would completely get rid of this pay-to-play, thing that big corporations do to abuse the law, right?
Right. Yeah. Which, by the way, so that is like a point of contention with people that, talk about property rights from the standpoint of like, who owns water, who owns the air, who owns, there are these.
No one. Conventionally, everyone. So no one can have a property in them is essentially
and so that's actually a very interesting point. It's like most of them will defer to the reason why, like, the Department of Environmental Protection needs to be involved in that situation, but truthfully it really doesn't. I'm like, they're kind of deferring to a de facto representation as far as that goes, but like you're saying, there could essentially be a class action lawsuit against a polluter of public space.
Not a class action lawsuit, because that would all be one lawsuit where everyone's interest is compiled into one. And it's possible, because I'm not a legal expert, right? Remember, I'm just here with this organization, the American Natural Rights Foundation. We're doing this legal research. We have people on the ground, doing it. But I can't say specifically. But in my understanding, remind me what were we?
I think you're saying that like each individual could file a notice and complaint and then a legal action.
Right, because we're not talking about the equity jurisdiction. We're talking about a court of law, and each person, you cannot represent someone else's interest in a court of law. It's just not a thing. You must represent or not represent yourself. You must be yourself. You understand?
So technically, I mean, like the at the very least, the collective population of the United States could have filed 330 million legal actions against Exxon, is what you're saying?
Yeah, I mean, if they could, if they could argue the case. I mean, if you're saying like, your little 6-year-old baby, I don't know, maybe your 6-year-old baby does have an interest in it. But I was gonna say, like, what interest could you argue that baby had, because it can't really experience the property, or the benefits of the property. But again, that's just like, but yes, apart from all the little particulars, yes, that's the idea.
Yep.
Right. And it's not far off. The idea is that each person, I care about Yellowstone. Like, I like to visit it. You know what I mean? I'm affected by that pollution that a company just did to a property that I had an interest in.
Yep.
Right. And while I don't hold title to it, whoever does have a title to it, maybe it's the state or whatever, they must have an imperfect title because I have an interest in it.
Yep.
Right? And it competes at least on some level. And I haven't studied the finer points. So like some things, you might find the state took the initiative to act as the representative of the people and then say that they were the ones who are going to assume all property interests but by what right? Go.
Well, and the problem is what they did was they essentially either assumed your consent or just couldn't care about it, right?
Right. So
and essentially took title from you.
Right. So go fuck yourself.
Yeah. Right. They're really good at that. They're really good at saying that.
Basically, what's so cool about our like the basis of the philosophy, like our underpinning of our institution, is that our grounds cannot be argued with. We have the most legitimate grounds, and we can point to the historical, evidence that proves that their arguments do not stand.
Yeah.
So it's like, as soon as the only thing that can argue with legitimacy is force. So what we need is to get the people understanding the law, understanding their rights, understanding the nature of the government and the authority of the government. And after that happens, nobody would think twice about breaking the law, because everybody's there enforcing it. Everybody understands, like, dude, you just did that. You know how bad it's going to be for you? You know what I mean? Like, if even if someone murders someone, right? Would you really help that person out? I mean, I would be like, no, dude, I'm washing my hands. I'm having nothing to do with this. I gotta call the police. That's the end of it. I can't have anything to do with such a criminal matter. Like, I mean, I don't mean like a self-defense type of thing, but I do mean, definitely, if it was self-defense, you should be the one calling. You know what I mean? Explaining what's going on and getting,
Well, and we discussed this too, like the idea of, I mean, just talking about objective morality. This is also something that, we could also talk about much deeper, but this concept of kind of like the final manifestation of understanding like true equal treatment under the law, or at least natural law, and the fact that we're just not there yet as humans. Like, we don't totally get it, so to speak.
Yeah, not everyone would have a conscience or is guided by their, some morality.
Well, and that's the argument against Machiavelli's noble savage, right? It's like the idea that, like, it's a nice idea, but, individuals will never get to that point where they are that noble, right?
I don't think so. Look at what we've been dealing with. I mean, come on. Do you know that the work week, I don't even know if I'm probably just pulling these numbers out of nowhere, but the work week used to be like way less than what it was. Yeah. Right? Actually, like, families, an entire other person could not work and be supported by the work of the original person.
One income,
like, that doesn't exist anymore. Like, where's the time to just reflect on anything, to think about anything, to study anything? Like, you've got to be super intelligent to be able to work out the ability to support yourself and do all of that. That most of the populace has actually been incapacitated, right? It's actually a tactic that they've used to busy us all up. And with the younger generations, to distract us with all the, flashy fun. I mean, they're awesome. It's completely entertaining. It's great. I can't deny it, but that's the point. That's that's the whole reason why it gets front and center, why it gets all the money, and that's why, that's why it exists.
Minecraft is the ultimate diversion from understanding your natural rights and how you're getting fucked over. Yes, yeah, exactly.
That's so funny. You know what? I would argue against that. I had a video teaching me about why you have to use aqua regia, why you have to in-court gold in order to refine it before you can. Anyways, you can do good things. You can free people. Yeah, when people have gold, right? That's a means of freeing themselves.
Yeah.
Anyways, so let's see here. Where were we? So let's see.
I believe we were on to valid waivers.
Oh yeah, thanks. Sorry, I was just like looking through the whole paragraph. Like, where were we? All right, so valid waivers, if you're ready. Presumption against the waiver of constitutional rights. So, a presumption is an assumption of fact that the law requires to be made from another fact or group of facts found or otherwise established in the action. A presumption is not evidence. A presumption is either conclusive or rebuttable, and conclusive being defined as serving to put an end to doubt, question, or uncertainty. But a conclusive presumption may be defeated where its application would impair a party's constitutionally protected liberty or property interests. And the power to create presumptions is not a means of escape from constitutional restrictions. So when a presumption tends to put an end to doubt and uncertainty, it still can't trump constitutionally protected rights. So a presumption is not evidence. A presumption is either conclusive or rebuttable. Every rebuttable presumption is either A, a presumption affecting the burden of producing evidence, or B, a presumption affecting the burden of proof. The burden of proof is a legal duty that encompasses two connected but separate ideas that apply for establishing the truth of facts in a trial: the burden of production and the burden of persuasion. In a legal dispute, one party is initially presumed to be correct, while the other side bears the burden of producing evidence persuasive enough to establish the truth of facts needed to satisfy all the required legal elements of a legal dispute. But even when they do enjoy, presumptive correctness, the burden to prove the presumption is fact actually falls to them when it implicates a constitutionally protected right.
Okay.
And because counter to presumptions made by government agents, that you've waived your rights, there's a presumption against the waiver of constitutional rights. A presumption means that the trier of fact must find the existence of the fact presumed unless and until evidence is introduced which would support a finding of its non-existence. So this means a jury must find must find against the waiver until the adverse presumption is that you have waived your rights is proved or substantiated with evidence.
Yeah. Well, so that is essentially, so like when you're being read Miranda, right? Like they ask you, do you understand these rights as they have been read to you, right? Like, and so there needs to be a specific, like if you are waiving any of those rights, there needs to be a specific stated waiver of those rights. And is there something to back that up? Like, does it?
Well,
do you also have to be proven to understand them?
Hold on, we're going to get to like a positive determination of a waiver, but this is like in the negative, right? Where they're using nothing to determine that you've waived a right. That's what we're discussing. And I apologize. Okay. Maybe I should have clarified that next. In the next section here, we're going to talk about those things that show what makes it a positive waiver. This is, you know what I mean? This is a presumptive waiver or whatever I'm trying to explain.
Sure.
So if two presumptions arise, which are so basically what that means is like I was saying with the jury, they must find that there's against your waiver, saying that you have not waived unless there is evidence to substantiate it, right? And so later we'll talk about what evidence would be that could substantiate it. But
fair enough.
If two presumptions arise which are conflicting with each other, the judge shall apply the presumption which is founded on the weightier considerations of policy and logic. If there is no such preponderance, both presumptions shall be discarded. So this means that the judge is obliged to protect your constitutional rights over giving credibility to presumptions which are unsubstantiated by competent evidence, which means evidence provided by someone with a witness under oath with personal knowledge of the matter. So then what does constitute an effective waiver? So clearly established, intentional, known, voluntary, and with sufficient awareness. So a couple cases have come up qualifying the answer to that question. In Poindexter v. Greenhow, it was established that waivers of constitutional rights, not only must they be voluntary, they must be knowingly intelligent acts done with sufficient awareness. And for waiver to be effective, it must be clearly established that there was an intentional relinquishment or abandonment of a known right or privilege. And that comes from Brookhart v. Janus. So a valid waiver can only be made of a clearly established intentional relinquishment or abandonment of a known right or privilege that was voluntary and done voluntarily and with sufficient awareness. So duress vitiates voluntariness. So duress is defined as unlawful constraint exercised upon a man whereby he is forced to do some act that he otherwise would not have done. It may be either duress of imprisonment, where the person is deprived of his liberty in order to force him to compliance, or by violence, beating, or other actual injury, or duress per minus, consisting in threats of imprisonment or great physical injury or death. Duress may also include the same injuries, threats, or restraints exercised upon the man's wife, child, or parent. Duress consists in any illegal imprisonment or legal imprisonment used for an illegal purpose, or threats of bodily or other harm, or other means amounting to or tending to coerce the will of another, and actually inducing him to do an act contrary to his free will. With freedom of choice as the guiding principle, it has been held that the element of voluntariness is vitiated under duress brought on by government action. Vitiate is defined to be to impair the quality or value of, to corrupt morally, to invalidate. So when the government uses means amounting to or tending to coerce the will of another, this invalidates and morally corrupts the voluntariness required to make a waiver of rights valid. And for those instances where we have been led to believe that we've waived our rights due to a contract or whatever, in Alexander v. Botsworth, it was decided party cannot be bound by contract that he has not made or authorized. Free consent is an indispensable element in making valid contracts. So if you didn't understand that the nature of the contractual agreement would destroy some essential right of yours, then the contract would be invalid because you never actually agreed to that term. Then it was actually hidden from you in the premise of the agreement, but it was never disclosed. And if you had no knowledge of the right at all, right, then the contract simply could not possibly be evidence of, that the evidence that you'd waived such a right. So there was a total absence of proof of the appellee's assent to the alleged agreement, or that its terms and conditions were free from doubt, speculation, and conjecture, or that there was a sufficient meeting of the minds of the parties to establish an agreement. And remember, a government official is a fiduciary for the public. If he intentionally withholds material information from them, he's guilty of fraud. Right? So neither branch of the legislative department, still less any merely administrative body established by Congress, possesses or can be invested with a general power of making inquiry into the private affairs of the citizen. We said in Boyd v. U.S., and it cannot be too often repeated, that the principles that embody the essence of constitutional liberty and security forbid all invasions on the part of the government and its employees of the sanctity of a man's home and the privacies of his life. As said by Mr. Justice Field, of all the rights of the citizen, few are of greater importance or more essential to his peace and happiness than the right of personal security, and that involves not merely protection of his person from assault, but exemption of his private affairs, books, and papers from inspection and scrutiny of others. Without the enjoyment of this right, all others would lose half their value. The makers of our Constitution undertook to secure conditions favorable to the pursuit of happiness. They recognized the significance of man's spiritual nature, of his feelings, and of his intellect. They sought to protect Americans in their beliefs, their thoughts, their emotions, and their sensations. They conferred, as against the government, the right to be let alone, the most comprehensive of rights, and the right most valued by civilized men. The right to be let alone? So, let me ask you, how let alone do you feel?
I have, most all of us are aggressed upon every single day. There is no letting alone.
I constantly feel like even my local community is organizing and bolstering the government, doing this or that, or asking for this or that. And it's dude, I don't have the time to deal with you. I just want you all to stop. Just stop everything you're doing and just stop.
Yeah.
So, let's see,
I get the impression, I know you have, we have, one last paragraph here kind of to take it home, but I get the impression,
too, but
I get the impression that the founders, everyone, all of the people that are kind of these relativists when it comes to, the living, breathing Constitution and all this other stuff, they all want to make it the founders never contemplated that, technology would come about and we'd live in these big cities with high rises and there would be automatic weapons and all this other stuff. They were they couldn't figure that stuff was happening. And I was
actually, sorry.
But so, to my this is probably not truthful, but my impression of what we're going through is always that, they were you know what, if you wanted to do that, great, but for the most part, we wanted to reserve the rights of the individual and his family that just wanted to, live in the middle of nowhere and not be screwed with. Like
Yeah,
that
yeah.
just becomes
Well,
extremely evident.
I wanted to mention a couple things. So the first one I was going to mention, it's has to do with Rome, and the other one has to do with Blackstone. To touch on the last thing that you were pointing out, but
Yeah.
the first thing with Rome is essentially like, oh, geez, why do I always forget my train of thought right when I'm about to say it? Um, oh, well, I'll just mention this part about Blackstone. So with Blackstone, remember that by the time Blackstone got around to kind of like producing that digest of the law of England. And that included a lot of the legal philosophy, right? The underlying philosophy that gave rise to any of the other stuff that's like invented in the mind, right? And that philosophy associated very fundamentally the happiness of one single individual human
Hmm.
with the epitome of the natural law, right? So anytime that we find that the natural law is transgressed, it's because we find it takes away from human happiness,
Hmm.
right? And any time that we find that something demands the natural law, it's because without it, it takes away from human happiness.
Yeah. Or what the founding fathers, what the framers of
Right. Within the
the
context
Constitution
of
would call the
the Christian
pursuit of
morality,
happiness.
right?
Right.
Yeah.
Yeah.
Well, I think there's an argument to be made, but it's definitely for all of the scientists to discover, right? What is the proper extent to which that gets taken,
Right.
right? But yeah, definitely through all of the study that Blackstone and others, other educated, people at the time knew, they were definitely educated in history. And like I was going to mention about Rome, is like Rome had a population, at least the city, I believe the main city of Rome, or the Roman city, the city of Rome. Sorry, not Rome, the whole
Yeah.
empire, but the city of Rome had like something like 1 million people, and I think some estimates go even as high as like 5 or 6 million.
Yeah.
So like to think that they didn't have historical examples to pull from to educate, like you're talking about the relativist idea, and they're like, oh, they didn't imagine. Like, no, you're way off. Like when you look at the things that these people produced, they published, that they wrote, their opinions, their ideas, what they reference, what they talk about, you can tell, dude, these people they were absolutely so educated. Like the only limit to their intellectual capacity was the development of, science. At that point, it was only so far. We only had so much scientific investigation and data and stuff for them to make conclusions on. But they were complete historians. They were absolutely educated on philosophy, logic, and all of the different things. So I wanted to ask you one other question. So, do you feel protected in your beliefs, thoughts, emotions, and sensations? And I think about propaganda here for the most part, but
Yeah.
think about anything, even just advertising. Do you feel protected?
Do I feel protected? No. I also, I mean, I would make the argument that it's my job at the very least to like protect myself and my family. Excuse me. But in
Well,
terms of like whether or
think of
not
the
I think
government
that
using
deferring, like that I've deferred that to someone and they're doing a good job, like even if I did assume that I was deferring it, no, they do a shit job of that.
No, I'm not saying the government as your representative doing it for you. I'm
Yeah.
talking about the government as your enemy using propaganda to attack you.
Oh, I do not feel protected at all. I believe that
Right.
there is a direct assault on pretty much
Yeah,
everything we've talked
exactly.
about.
Exactly. See, sorry, I didn't mean to like. I kind of
No,
get
that's okay.
where you're coming from with that. I'm sorry. I was thinking more in the way of like government is turning out to be quite of an enemy, right here. And in fact, remember we talked about government does no wrong. So really, all of those people who claim to act in the state. Remember we talked about
Well,
color
no,
of
they have
color
personal
of office.
culpability, right? Like
Yeah.
they have
Yep.
personal
Liability.
liability. Yeah.
Yep. Yep, and that's the main thing, that as soon as, these processes get, utilized, we're coming after individuals. Like it has nothing to do with the government or the dignity of some profession or anything like that. We're coming after particular criminal actors or
Yep.
violators. Yeah, it's really awesome. In fact, it talks about how public officials who violate their oath to the Constitution actually are committing acts of treason. And the law, they refer to it as warring against the Constitution. But it says constitutes treason. So there's no ifs, ands, or buts about it. Basically, these people are criminal actors that need to be the law. We have the law. It's been taken from us. We've been led to believe that.
Which, in our discussion of lexicographic falsification, the word treason has been flipped on its head to be the inverse of that.
Well, right now, when you stand for liberty, for sure.
Yeah. So, we got one last paragraph here. Yeah. Take it home.
So, in this excerpt, I just want you to remember that it's speaking from a frame of reference where, before political philosophy had developed to the point of being able to conceive of a form of polity that was, not an oligarchy, democracy, or monarchy.
Okay.
But the main part about this is pay close attention to what he points out is the singular aspect that legitimizes civil engagements, right? So remember, our city right here, your city, every city you're in, every state you're in, those are civil corporations. So those are right. So those are corporations. Civil corporations is the nature, and so when he's talking about civil engagements, that's literally all of the political scene, right? Everything that we have. What is the sole aspect that brings legitimacy to that? So it says, so that the social pact not be a pointless device, it tacitly includes this engagement, which can alone give force to the others, that whosoever refuses to obey the general will shall be constrained to do so by the whole body, which means nothing else than that he shall be forced to be free. For such is the condition which, uniting every citizen to the fatherland, protects him from all personal dependency, a condition that ensures the control and working of the political machine, and alone renders legitimate civil engagements, which, without it, would be absurd, tyrannical, and subject to the most enormous abuses. So not only was it a prerequisite, for a non-arbitrary government, that the people in every generation be in a position to accept or reject it, but to add to that, right, the nature of a general legitimacy of civil engagements, which includes all political actions and actions by the state, can only be attenuated by protecting him from all forms of personal dependence. Isn't that
which is coming from Rousseau here?
Yeah. Yep.
Which most people would completely not even believe that this was him saying it.
Well, the thing is, people don't understand that, okay, this is what's so beautiful about the natural law. It's never going to go away. Do you want to know why? Because just like gravity, just like thermodynamics, these laws assert themselves every day consistently, no matter what you do, no matter what. That's how it works. And so why do you think, a political philosopher of the 17th century is wrestling with these ideas, trying to figure out how to fit the natural law, which is what he doesn't understand he's talking about, into the political societies he's been led to believe are the only forms possible, right? Because in his conception, in their conception, you can't divide the sovereign will, that it has to be a unanimous consent. That's why you get a democracy, an oligarchy, or a monarchy, because in each of those instances, they're 100% unified, right?
Yeah.
Either by a majority or by unanimous consent in a democracy, right? So, what's great about the natural law is that it constantly asserts itself. So basically, no matter how it's going to be hidden or covered up, it's always going to come back. And people like you and me, people like Rousseau, who are just trying to figure out liberty, figure out the proper philosophy of living for mankind, because he has to live with others. How does he actually affect that? Well, we figure out the natural law because it's a natural consequence of concerning yourself with civics, that branch of philosophy dealing with natural rights.
Yeah.
Mm-hmm.
That is at the very least, it's a silver lining, right? I mean, considered.
You can see in the law, it really does. Thinking about the idea of a government really being composed of nothing more than a magistrate and a sheriff. I mean, That's pretty remarkable. Like I agree with something like the police or some kind of emergency services being there, fire, health, whatnot. I think that makes sense. But I mean, you can understand that a majority of everything that ever had to do with anything, like, oh, there's a taillight out. Well, if someone has a problem with it, they can file a lawsuit against that person.
Yeah.
There's no reason why, right? Until that person actually gets in an accident and that person who got in an accident with them goes, you know what, it was because your taillight was out and I didn't see you or whatever. It was actually related to the damage of the property, right?
Yeah.
That's when you can now say, look, I think it was reasonable that your taillight was fixed, that you should have been driving around with it. And that's in my points and authorities in my cause of action. And if you, agree, if you don't ignore the court, I'm bringing this lawsuit before it. The jury is going to decide whether that's reasonable, whether you should or shouldn't have, had your light in this particular instance, which gave rise to, at least my evidence will show, it gave rise to the damage of my property. So anyways, yeah, the law
Yeah.
really does have an answer to everything. And unfortunately, like, it's really amazing when you learn in history that there were more American law books sold in, I'm sorry, there were more English law books sold in the American Isles than there were in England. Like, because our founding fathers, they took the law very seriously. They really saw in it the freedom, the process to the freedom of mankind.
Yeah.
And like one of the main things that they did was when they participated in their grand juries, they would always say, nope, there's not enough evidence here to bring to trial. So they would basically stop the state in its tracks by not allowing anything to ever go to court.
Yeah. And,
Yep.
well, and everything that we've walked through too, just talking about, juries in the process of the court, it makes it seem like, it was always like this assumption when I was younger. It was always this assumption, especially when you watched like court cases play out, on the TV or even like in fictitious dramas and stuff like that.
Yeah.
It's always like, oh, the burden of proof is on the state, right? Like that was always that kind of like trope that they would always say, like the burden of proof is on the state. Like it happened in the OJ trial, right? Like if the glove don't fit, you must acquit, right? Which is actually true. Like there needs to be a mountain of freaking evidence against someone.
In the law. And I'm not a legal professional, so I can't say, but I believe also in equity. But one of the interesting things is it's not true in the admiralty jurisdiction. Mm-hmm. So military courts actually, the assertions are believed to be, they have that presumptive correctness, and the burden of proof is on the defendant. But it's interesting because like this is part of where we come from in saying, that there are competing theories at different levels and at different places in the government, because just like you're talking about, like a fundamental principle that's like required, right? Somehow is being obfuscated. But how is it possible that everybody who can see it blatant, right on its face, how can they be getting away with something like this? There's got to be some Boy Scout who's there, who's like, not on my watch. You know what I mean?
Yeah.
It's like, how is it possible? Well, when you consider a lot of the different evidence, just like this, like we're saying, like, okay, well, this is a principle that they would have to abide by. So do we see any other legitimate explanation? You find so many of these things, these behaviors on the federal and upper levels are explained by the idea that we are under an enemy, we are under a military occupation by a foreign enemy, and we're essentially at war. And that their actions, so this is another interesting part about it, that their actions, which cause us to be, lies, basically, that cause us to believe untruths in international law, because that's what it would be if it was another sovereign nation or body that we were at war with, that was a hostile enemy. They would be able to, under the law of nations, which doesn't have to do with our Constitution, doesn't have to do, right, they're above it, because they're not a creature that came from within it, right? They're a creature that came from beside it. And so deceit is actually a tactic of war and is not fraud. So in international law. So that's a really interesting spin on like you'd understand after, the Civil War. We'll talk about this, I think, next time. But after the Civil War, the states were forced to rewrite their state constitutions, banning a bunch of different stuff. And the federal government made, was it incorporated states of the federal, or incorporated territories of the federal union, or of the federal government, sorry, that we now associate with and live inside, as opposed to the conventional states of the union from the Constitution that were basically created from the Constitution. So it's interesting when you get into the depths of the law. There's some rabbit holes.
I can't wait to get off of this broadcast and then direct message Shane Hazel and tell him that we are currently at war with a invading authoritarian police state. I think he would be on board with that.
We're definitely looking into it right now. But yeah, I mean, if there's anybody who wants to participate, I mean, we absolutely have an endless amount of work, both on the administrative side and on the research side. So, and again, like if you have an interest in teaching people this stuff, if you want to teach people how to use legal process to remedy the wrongs, like we can empower you by, if you want to volunteer, definitely come hit us up.
Yeah. And so anyone who is looking to find more information, go to MT as in Montana, MT dash ANRF.org. So MT-ANRF.org. And hopefully, does MT stand for Montana?
Yeah, and that comes from the American Natural Rights Foundation. That's where ANRF comes from.
Awesome. Well, look, another fantastic episode. Like, so much to digest. I think we ended on a good note because now I know I'm not crazy.
No, that was so awesome. You find everything in the natural law substantiates everything you kind of knew written on your heart.
Yeah. No, it's pretty eye-opening. I would say that it's affecting me the same way that it did when I read Anatomy of the State for the first time by Murray Rothbard.
You know what that is?
What was
Sorry.
that?
No, go ahead. He was what?
I'm saying, like, it's hitting me the same way. It's like things that I always kind of knew viscerally, but I just couldn't put words to it, or I just couldn't find a source that echoed what just inherently I feel. And I think a lot of people feel the same way and have the same problem. They just can't put it into context or into some kind of material, philosophy.
I'll do you one better. So again, like I come from more of a scientific perspective. And so like in that realm, you really don't make any conclusions without having some kind of evidence to back it up.
Yeah.
And while you'll get introduced to these concepts with a bit of evidence, like, oh, I'll talk about this, I'll talk about that, you really want to you want to be sure. You want to really investigate. You know what I mean? You want to get down to the nitty gritty and get all the parts and all the things. And so I can tell you, for a while in the beginning, it's a wonderful, marvelous dream that they sell you with this idea, right?
Yeah.
And so for a while, I was just like, I'm not sure if I'm willing to let myself believe it, because if it turns out that it's totally not, then that's just shitty. So let's better keep our eyes open and see what we can find that nullifies this, that says this isn't the way it is. And when you go back, you find their words are like the most beautiful articulations of this truth that you could ever find. Like, we couldn't do a better job than this. And it's like, wow, I thought I was over here afraid that I was going to get told it wasn't true. And what I found was everybody knows this is the truth written on everybody's heart. Yeah. And the only people who don't pay attention to it are power hungry usurpers. Right?
Yeah. Or what's even scarier is that they know it and they choose to go around it or manipulate it, or that's even scarier.
You know what it is? And I don't really associate any of this with the organization, so I'm kind of going off on my own thing here.
Sure.
But just secret organizations, as you might know, as I might be referring to, different occult collectives of a particular nature, their philosophy is actually resoundingly similar to the natural law, but instead of the natural law for us showing, like we talk about with objective morality, it creates just like the law of gravity, right? Or like the law of, okay, so the strong and weak theories or
nuclear forces.
Sorry, are like holding together matter, right? And to a large degree, and so is the thermodynamic forces, and so like driving into a wall, right? You're ignoring all of these laws of reality, and the inevitable consequence is your death, the dissolution of your existence.
Yep.
But like so that basically for us, we see in the moral law the walls that we must live within. Whereas for people who are of this particular persuasion, their philosophy basically says there's no limit to the correctness of self-assertion. Or, you know what I mean, of self-determination.
Yeah.
And so it's basically, that's like the two main, those are basically going to be the two schools of thought that are going to compete for the next, 500 years or something. Yeah. And over 500 years, we'll find out in those pockets that chose one philosophy, how bad that was. And those who chose the other philosophy, at least as far as I believe, I'm more of a naturalist, and I believe in like the science of the law, that there's a consistency and a concreteness, there's a formula to it and everything. And so I'm prone to think that when you follow the law with objective morality, you'll have basically, almost like a heaven, if you will.
Well, and we've talked about just in general, like Mark Passio and kind of some of the things that he says. And
he's great to articulate this stuff.
Some of what he said was really also, again, one of those things where it kind of like hits me viscerally, where he basically said where morality essentially becomes more relativistic, you end up with less freedom and more slavery. Whereas when morality becomes more objective, you end up with more freedom and less slavery.
Do you want to know why? That's the natural. Sorry, go ahead.
Go ahead. Yeah, sure.
I didn't mean to cut you off. It was rhetorical, right. But I appreciate an answer if you wanted to.
No. Go ahead.
Okay. Well, I was going to say the reason why that happens is, like I was saying before, the natural law asserts itself. So you can try all you want to cover up what is the reality with whatever you build a society, build a device, whatever it is that you make, whatever it is, it will be destroyed. It will fall apart inevitably if it is contrary to natural law, right? So just like unsustainable farming practices, right? Like the soil doesn't produce what it produced anymore. Like, that's just ignoring the natural law. Like, that's just, you see what I mean? The natural law, if you ignore it, you're going to have some consequences.
Well, what you're saying is by ignoring it, the
you think
reaction.
You can murder someone because relativistically you think that that's just a whatever. See how long you'll be able to survive on the earth without getting locked up or killed. Because people will not have it. And why? Because that's actually one of the more self-evident natural laws. Right. I mean, there's some like quantum mechanics. Like quantum mechanics took a long time of scientific investigation to even discover. Newtonian physics, that was almost one of the first ones we saw, right? Yeah. You see what I mean? Like, freedom or liberty, life, and pursuit of happiness. Those were the most fundamental ones. A system of dispute resolution. That's like literally, that's going back to, Roman society and their contribution to the natural law. So like, the end result will be the natural law, no matter what. Because
in your example, the awful things that come in the middle, right, from the time that folks are basically violating or going against the natural law to the point where the natural law emerges again, is awful because of that conflict where the natural law continues to shine through. And so, like an example like slavery, like there's not any good slavery because people refuse to be slaves, like they refuse to be cattle. But to a certain extent, like the fight back of natural law causes that authoritarian nature of slavery because they have to try and bridle it and go against it. Yeah, I mean, it's almost like the idea of entropy.
Don't concede. Yes, they don't concede their will to the objective morality now you got to create a political society to enforce some kind of will that's decided by something that's not you. You see what I mean? It's crazy. What do you call that? Cascading effect.
Yeah.
You know?
Yep, most definitely. So, well, look, we got more to talk about. I love this. This was good. And we're going to be back in 2 weeks, so 2 Thursdays from now. And hopefully, do you have plans for the holiday weekend, or are you just hanging out?
Well, I'm actually headed to Seattle for a little work vacation for next week. So
okay,
be a little
interesting.
Fun.
Yeah, it should be fun. So have fun in the Pacific Northwest. I'm back Monday on the holiday, live at 7. I'll be giving away some crypto. So
Awesome.
yeah, anyone who's made it this far into the video, please, it's an open giveaway. You just need to start an account and do a post. So definitely get involved in that. So
awesome.
Josiah, thank you very much. Have a good evening and have a good weekend.
As always, you too.
Bye now.
Have a good one.